Okay, we might as well get started right now so we can get out as quickly as possible. John Campion will now deal with the next topic on the agenda, which is evidentiary problems in relation to litigation with a foreign element. John is practicing at Fasken and Calvin, where his practice is exclusively in the area of litigation. I suppose primarily in the area of commercial litigation. He has been an instructor at the Bar Admission course, as well as being a guest lecturer at both U of T Law School and Osgoode Hall Law School. Extensive experience in the area of litigation involving a foreign element, and in fact, John was one of the counsel who were involved in the leading case on service ex juris, which is the Singh versus Howden case. I don't know whether you won that or lost that, did you? You won that. He could have given the talk that Sheila Block gave on service ex juris, because that was the Singh case was the leading case, but he kindly agreed to deal with the evidentiary issues in relation to parties out of the jurisdiction. I'll turn it now over to John Campion.
Where's this thing we're just doing? Other side? Since this whole entire series of lectures is about strategies in litigation, I thought I would just comment on the Singh case. That series of motions functioned on the deep pocket theory. The motion before the master took place in 1975. We went from the master to the Supreme Court, then with leave to the divisional court, then from the divisional court with leave to the Court of Appeal, and we finished in the Court of Appeal in 1979, and you can imagine the amount of money. Singh was, and still is, bringing an action against a number of companies sitting in the, starting with Shell England and carrying on through a number of subsidiary companies here in Ontario. As a strategy, it is a very good one. I don't suggest for a moment that it's a proper one or that it was followed in this case, but certainly that deep pocket theory for a small litigant, as the three Singh brothers are, has caused them to rethink their strategy from time to time. In any event, there's also a number of other small little points that struck me as I was going through, the unrelated directly to my topic, but may help you avoid difficulties. One particularly important one is where you are advising a client whether to defend or not in an action in Ontario. You should, I think, seek the advice of foreign counsel for a number of reasons. The obvious reason is whether they can raise in the foreign jurisdiction defenses which they can raise in Ontario, having regard to the service. And also, very importantly now, as more and more countries look to currency laws and currency restrictions from time to time, and South Africa is one of those countries, you find that you may be able to register the judgment and have the judgment, but you have to get permission of a minister to actually enforce the judgment, and then having enforced it, you may not be able to get the money out. You have to use it in the country where you are. You can't actually take the funds out. Anyway, those are just some of the little problems which I've run into as of late. My topic, though, is dealing with foreign law and its use in Ontario, and the obtaining of that foreign law in particular, also obtaining evidence of witnesses who reside outside of Ontario, or assisting foreign courts obtaining evidence from people who reside in Ontario. And finally, I will make just some comments on some new statutes and some comments on whether tribunals, such as the Ontario Energy Board and the Ontario Municipal Board, can or cannot use the same powers of a superior court to obtain evidence. At the outset, I would like to thank Mark Lecourcier of our office, who helped me prepare the paper which you have. I'm not really going to follow the paper directly. Most of the things that I'll have to say will be in the paper, and certainly all the cases which I cite are listed in the footnotes, but I'll leave that for your own reading if you see fit or have a problem in the area. Also, Gary Watson was kind enough to call and tell me about something which I wasn't aware, and that was the Uniform Law Conference of Canada and the Uniform Evidence Act. There is some possibility that that Uniform Evidence Act, which is a Canadian statute, will be passed very soon, he informs me. And also he made mention of an act called the Interprovincial Subpoenas Act, which has actually been enacted but not proclaimed. And that will provide and make easier for those reciprocating jurisdictions in Canada to issue a subpoena anywhere in Canada, and thereafter the witness who comes to Ontario, or vice versa, has a number of protections. He can't be served with any other process, and a whole series of protections that are set out in that act so that he can come to Ontario with impunity just to give evidence. It's an advance which, if followed right across the country and reciprocating jurisdictions exist, will make the problem of obtaining evidence outside of Ontario but in Canada a lot easier. In any event, the first topic that I propose to deal with is foreign law. And I won't, needless to say, deal with a lot of the complicated issues as to whether foreign law can be used in Ontario, other than to cite the general principle. The starting point is that the enforcement of a foreign or domestic right is a matter of procedure, and you follow the law of Ontario. Assuming you are here in Ontario and you're adopting Ontario procedures, the court thereafter looks at the substance of the matter to see whether the law of Ontario applies or whether the law of the foreign jurisdiction applies. In determining whether the law of the foreign jurisdiction applies, one has to make a very difficult distinction between substance and procedure. It's difficult for a number of reasons. One, each little issue is very complicated and has a number of cases going, depending on the facts, in various directions. And in particular, for one set of facts, you may have somebody saying, no, it's the lex fori, it's Ontario law which will be applied. In a different set of facts on exactly the same principle, it will become a matter of substance and not a matter of procedure. And as a result, you then have to lead the evidence which will allow you to rely upon the foreign law, assuming it's in your favor. As an example, an irrebuttable presumption of law is a matter of substance. As a result, you have to plead it in an Ontario action to rely upon it if it's from a foreign jurisdiction, and the foreign jurisdiction is different. If it's a rebuttable presumption, that's in the main a procedural point. So just on evidence alone, you can get very complicated. The existence of a right of action, say there's a Limitations Act which limits the right to the remedy. That's a matter of procedure. If the right to even bring the action is limited, that is, say, some form of condition precedent, that's a matter of substance. So if you had a case, as there was in New York, where you had to have permission of a New York court to bring any action, that's a matter not of procedure, but a matter of substance, and you had to plead that law. It was pleaded and successfully followed here. I am going one step further, though. Rather than discussing those issues as to whether foreign law applies, I'm assuming it does. And really the question is, how do you prove it? First of all, there are 5 ways. One is by judicial notice. The one most often used is by pleading and proof. The third one is by way of presumption, and that is simply where you have a foreign law element but haven't proved it. Even though you've pleaded it, the law is presumed to be that of Ontario, or the lex fori. The fourth way is by admission on the pleadings. And the fifth way is by agreement between counsel, so that counsel can agree to look at and interpret foreign decisions. You can go that far. The judicial notice is one that is minor, and I can just point it out to you and leave it. Basically, the Supreme Court of Canada takes judicial notice of all the statutes in each province and territory in Canada. The proof by pleading, I've dealt with presumption. Admission is easy. Agreement is easy. And I'm going to concentrate, obviously, on the only topic left, and that's pleading and proof. Foreign law is considered a fact. And you prove it like you do any other fact. You have to plead it. And in foreign law, you have to not only set out the law, but the effect of the foreign law in your pleading. You then are compelled to adduce evidence to prove it as a fact. That proof can be done in a number of ways. It can be done by statute under the Ontario or the Canada Evidence Acts. with respect in particular to statutes and proclamations in other provinces of Canada or in other British dominions. Any non-British dominion, you can't rely upon the Evidence Acts to prove it. Again, you can have proof by way of admission and agreement, and the final way is by expert evidence. Now, it's that expert evidence which I will concentrate on. Usually, the expert who is called will be one who has practiced in the foreign jurisdiction. I would expect that the best evidence you could get is a person who has practiced in the foreign jurisdiction and then been a judge in the foreign jurisdiction, and in particular practiced in the area in which you called him to be an expert. It's an obvious point which may be too simplistic to state, but in this area in particular you should be careful to have the expert, or is in that area if you possibly can. By that I mean don't try and overextend your witness past the point where he can reasonably be said to have practiced in that area. Just because he's from the country doesn't necessarily mean he's going to be qualified as an expert. The fact that a person has merely studied law of that country in Ontario is not enough, although I did hear in the conversations that in California they allowed a professor who had studied California tort law to give evidence as an expert, even though he never practiced and even though he had no other connection other than studying about that jurisdiction. If the foreign law is foreign in essence, that is particularly difficult concepts, then your expert has to be even more qualified, and there's a stricter observance as to his qualities. You can also call a person who holds an office in that country who may not have practiced, and that in particular I would be thinking of an attorney general of a country, someone who has a close connection with the law. Assuming that you have actually called the expert and led your evidence, having pleaded it and pleaded the effect of it, there is a subtle distinction here. The effect of the law, having regard to its principles, is one thing. The effect on the case of the parties is a matter of substance, is for the Ontario court alone to decide. Now, it's very difficult to draw that line, obviously, as to the effect of the law outside the facts and the effect of the law on the facts themselves. But that's the principle easily stated. Now, one interesting case shows why you should be careful with your choice of expert. An expert was called in a family law matter in a case called Vicari versus Vicari, and he was asked to deal with the New York law and the effect of a Mexican divorce in New York. He gave evidence about that divorce and the law in New York, and Mr. Justice Callan in that case refused to follow the expert's opinion, looked at the decisions himself, and found that indeed it would be recognized in New York. So, depending, I take it, on the quality of your expert and the quality of the advice he gives, you may find that just having led the evidence isn't enough. Now, the whole topic of expert evidence in this area and the use of it is long and difficult, and I don't propose to do anything more than to mention it as much as I have, because the rest of the lecture is also very long. But one thing I would point out, and this is thanks to Master Sandler, in the area in particular of expert evidence, but also in other areas, you may have to go to the foreign jurisdiction by way of evidence de bene esse, or potentially, or obviously more appropriately, evidence by way of commission, and obtain the evidence there. A judge would be reluctant, because of probably the controversial nature of the evidence, to allow it. But the impact of modern technology may help deal with one of the objections to having evidence taken by commission, and that is the use of videotape. Because when dealing with evidence for de bene esse or commission evidence, there's a wide discretion as to how it's taken in the master. In Ontario, you may apply, in this era of modern technology, to have videotaping of that evidence and reduce the problem of not being able to see whether a witness is credible or not, to watch his demeanor, to watch the examination chief and the cross-examination. It's just an idea, But I think that more and more, as problems become international and as technology becomes so much more sophisticated and cheap, you're going to find that those kinds of applications, and in fact, Ron Slaght, I'm told, has even got such an order to take evidence. I don't know whether it's outside the jurisdiction or inside the jurisdiction, but he has such an order to use videotape. The next part of my discussion is a nuts and bolts area, and that is when you have an action in Ontario and you've got a witness outside of Ontario who either resides permanently or temporarily outside the province, how do you get evidence, one, for discovery, and two, for trial? And a subsidiary point is, if that witness will not voluntarily give evidence outside the jurisdiction, how can you compel him to? I'm going to deal with examination for discovery quickly and leave it because it's basically a simple discretionary matter. It's under Rules 327 and 328. 327 deals with an individual. 328 deals with a corporation. Where a party, and obviously it can only be a party, and I make the distinction between a witness and a party in this case, resides out of Ontario, or even is temporarily out of Ontario and not resident here, an order may go providing for his examination in a foreign jurisdiction. And the test is as wide as you can have. It's what is just and convenient to the parties, and each case is basically decided on its own merit, having regard to that general wide test. The order, if asked for, may be made for the party to attend in Ontario, or may be made for the solicitors in Ontario to attend out to examine that party. The procedure involved is simply a motion to the master under the appropriate rule with supporting affidavits, of course on notice, and the order is the one which can set out in a wide way as to how, where, and when the examination is to take place. That's examination for discovery dealing with a party. It's the evidence for trial which is more difficult. And you may be dealing with a party, but more often you're dealing with a witness. There are two means of doing it. One is evidence de bene esse, and the other one is by way of commission. If you do not think that you are going to have any trouble actually getting the evidence, in short, you're not going to need compulsion from the foreign jurisdiction to make that witness come forward and give evidence under oath, then an application for evidence de bene esse is the appropriate procedure under Rule 270. A party can apply to have himself examined outside the jurisdiction, although in the case of a plaintiff, the case law is that the discretion is very strictly dealt with. If a plaintiff has chosen the jurisdiction, then he's expected to be here for trial. And all of this evidence is for trial only. If it's a defendant, it is slightly less strict than a plaintiff because he hasn't chosen the jurisdiction, and for some reason or other, he may not wish to be in Ontario. The jurisdiction to allow for evidence de bene esse under Rule 270 is part of the common law inherent jurisdiction brought through by the Judicature Act. There must be, under the rule, litigation pending. You cannot use this rule to obtain evidence prior to the time that an action is actually commenced. Normally, the rule is used where a person is so ill or so infirm that he cannot or she cannot attend in Ontario, but you don't need that alone. There may be some other reason which allows you to invoke Rule 270 versus going the approach of getting a commission. You must show a number of things. You have to show that the witness is unable or refuses to come to Ontario, that the evidence is material, that the application is bona fide, and in particular, that deals with delay. You should not bring this kind of application on the eve of trial unless it's extraordinary circumstances because of the delay involved. You have to show, and throughout both commission and evidence de bene esse, commission evidence and evidence de bene esse, you have to show that the evidence is used for trial. If there's any clear principle that jumps out in all of these areas, it's that. it is not frowned upon, it is not often allowed where there is going to be an issue of credibility surrounding that witness's evidence. And again, the advance of modern electronics may reduce that problem to some extent. Now, when you go to use evidence de bene esse at trial, you have to, before even using it, show and establish that the witness is either dead or is still unable to come to Ontario. So it's a double test. You've got the test at the time of the motion and the test when you try and use that evidence at trial. Either party may use the evidence, and neither party can choose not to use the evidence. So that if a party who advances the need for this evidence gets it, brings it to Ontario, he doesn't necessarily have to use it, but the other party can. If you have applied and you don't use it at trial, then you may be paying the costs for everybody. The procedure is a motion before the master. The order sets out the usual things that are necessary. Obviously, examination and cross-examination are allowed. Now, if you, for some reason, cannot get evidence de bene esse, and that is usually that the person refuses to attend as a witness in the foreign jurisdiction, then you must use Rule 276 and obtain a commission in Ontario to get that evidence, and thereafter, or at the same time, get letters rogatory to assist you to compel, or letters of request, to assist you to compel the witness in the foreign jurisdiction. Again, the same principles with respect to parties apply, and that is a plaintiff can apply to have his evidence taken by commission, or a defendant can apply to have his evidence taken by commission. And you need very strong and positive reasons to have a plaintiff in that position. Generally, with respect to a witness, the tests are not dissimilar to those tests which are applied under Rule 270. Again, the application must be bona fide. It must be in particular for trial. It can't be used for delay. You should bring it after the examination for discovery, but well in advance of the time that the matter will come up for trial. You have to show, among a number of other things, that the witness will give evidence on a material issue, and that the issue is actually significant to the dispute, and that the evidence will be significant for that decision regarding that issue. You have to show that there is good reason that the witness cannot be brought to this jurisdiction, usually that he won't come at all, and that the examination will be effectual. Having done that, you'll get an order appointing usually a barrister or some other person in a foreign jurisdiction as a commissioner to take the evidence. Some of the reasons why these applications are refused are delay, the timing, that is before the examination for discovery, and basically the reverse of all the things that you have to show in your affidavit. Practically, you bring the application before the master, naming the commissioner, setting out all of the items and tests in your affidavit. The affidavit has to be very complete, and you don't get letters rogatory unless you can establish that that witness will not come forward. So you actually have to have evidence of that, and you may not be able to do so until you get a commission in the first place to take the evidence, and have the commissioner in the foreign jurisdiction invite that witness to come forward to him to give evidence. If it's refused, then you've therefore got your evidence. So it may be a two-step process, depending. The actual carrying out of the commission in a foreign jurisdiction depends on two things. There may be a bilateral treaty with the country where the witness resides, or the place where the witness resides. If there is, then you must have regard to that treaty and follow the terms of it. And on page 22 of my paper, I've set out all the countries which Canada has a bilateral treaty with. If there is no treaty, then it simply varies from country to country. If it is a common law jurisdiction, then there is usually very little formality and very little difficulty. If it's a civil law jurisdiction, you may be met with very stringent requirements. There are 3 methods to obtain the evidence, depending upon the laws of that foreign jurisdiction. The usual and best one is to have an examiner appointed and have examination and a cross-examination before that examiner. But the law of the land in the foreign jurisdiction may provide that you can only have evidence before actual authorities and court authorities, in which case you have to go through a very long and difficult process and an extraordinary amount of delay sometimes to get that evidence actually taken by that foreign person. If the witness will not attend, then the letter is rogatory. You obviously have to show the witness will not attend and that you need the authorization of the foreign court. What the letters rogatory are simply a request of our court requesting the foreign court to lend their assistance to compel the witness to come forward. And rather than, I have about 5 minutes, rather than spend any more time dealing with the actual mechanics of letters rogatory, let me deal with a few cases in Ontario where a person from outside the jurisdiction wants to have a witness in Ontario give evidence pursuant to letters of request. One case, the Executive Security Commission case, and these are all cited in my paper, a grand jury in the United States made a request for evidence, and that was held not to be the request of a foreign court. And as a result, the application was refused. It has to be a foreign court. In the Westinghouse Electric Corporation versus Duquesne Light Corporation case in Ontario, the evidence was refused for a number of reasons. And again, this is back into these uranium cases. 1, the evidence was not for trial. 2, it was against public policy in Canada, and that public policy was led through the Attorney General of Canada. And thirdly, it was in contravention of the regulations for secrecy passed under the Atomic Energy Control Act in Canada. For all of those reasons, that application was lost. The most important part of that was that the evidence was not for trial in terms of general application. Another case deals with whether a corporation can be compelled by foreign letters rogatory with an application in Ontario by originating notice under Sections 42 and Section 60 of the Evidence Act to have a company give evidence. And it was held in the Medical Ancillary Services case versus Spurry Rand that a company can't be compelled to give evidence, but it could be compelled to give up documents. So an Ontario company itself cannot be examined. Per se, you have to examine a person. The actual principles and tests which are applied basically are, in addition to some of those points, you obviously have to show that the evidence is for trial, that there is a proceeding in the foreign court, that the foreign court is entitled to make this request, and that it has powers in its enabling statute to do so. And a number of other tests which basically sometimes depend upon individual facts which may arise. Before I finish, let me just deal with 2 things, and that's tribunals in Ontario and federal tribunals. Federal tribunals, in my view, cannot compel evidence from abroad because there is no reciprocity with federal tribunals under the Canada Evidence Act. It has been held that under the Canada Evidence Act, you can't force a foreign tribunal, non-court, cannot force a person under the Canada Evidence Act to give evidence because it is not a court. That is not so necessarily under the Ontario Evidence Act. And under the Energy Board Act and the Municipal Board Act, those boards, for the purposes of getting evidence, have the powers of a Supreme Court. They might, although it's never been done, they might be able to compel, because they have those powers, they might be seen in the foreign jurisdiction as a superior court, and as a result, you would be able to obtain evidence. And in fact, I've actually been, I don't know how it's going to turn out, but I've actually been retained to try and do that, to apply to the Energy Board to issue a commission letters rogatory. I don't know whether it's possible or not. I've come to an end. I hope that that's been of some assistance. I'm sorry I couldn't spend more time on the topic, but it's a wide one. Mr. Blash.